Welcome back to the courtroom, where today's case takes us deep into the struggles of addiction, probation, and second chances running out fast. We are watching the story of Megan Hayes Wilhite, a woman who was given probation for burglary but now finds herself back before the judge after multiple violations. The stakes: up to 10 years in prison. The prosecution is pushing for a harsh sentence, while Megan's defense argues she needs treatment, not time behind bars. And at the center of it all, did Megan truly try to turn her life around, or did she squander every opportunity? As we go through this case, notice the tension: a defendant pleading for rehabilitation, a state pushing for punishment, and a judge trying to balance justice with compassion. Who's right here? Stick around, this case has twists, contradictions, and a powerful ending you won't want to miss.
All right, so what are you saying happened with outpatient treatment?
I hadn't gone to the outpatient treatment yet.
All right, why not?
I had been working and I didn't have time to do it at that time. I hadn't been able to make time yet.
All right, so this is what I'm trying to get to. One, was outpatient treatment ordered for you, yes or no?
Yes, ma'am.
All right. Okay. All right, the court is calling 2020 CR 2272, State of Texas versus Megan Hayes Wilhite. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
Kelly Piddle.
And are you Megan Wilhite?
Yes, ma'am.
Am I pronouncing your last name correctly?
Yes, ma'am. Wilhite.
All right. I'm going to show you what's entitled Motion to Revoke Community Supervision and First Amendment Motion to Revoke Community Supervision. Did you review those documents with your attorney? Did
Yes,
you
ma'am.
understand them?
Yes, ma'am.
Are you the same Megan Hayes Wilhite who was placed on community supervision in 2020 CR 2272 for the offense of burglary of a habitation force on August 29, 2022 for a term of 6 years?
This is a critical moment. Megan just pled true to not one, but two serious probation violations, failing to report and committing theft. By admitting this, she's essentially handing the judge the power to revoke her probation and send her straight to prison. The defense knows this is risky, but perhaps they are hoping honesty will work in her favor. Viewers, let me ask you, would you have pled true here, hoping for leniency, or fought harder to keep probation?
Is that you?
Yes, ma'am.
All right, state.
Violated condition number 4 in Bexar County, Texas. The defendant, Megan Hayes Wilhite, did then and there fail to report to the supervision officer as directed for the months of April, June, and July 2023 in violation of condition number 4.
How do you plead to that? True or not true?
True, miss.
And Judge, this is going to be on the first amended motion to revoke. It's violated condition number 1 on or about the 26th day of September 2023 in Bexar County, Texas. The defendant, Megan Hayes Wilhite, committed the offense of theft in violation of condition number 1.
How do you plead to that? True or not true?
True, miss.
Your Honor, state waives all the violations.
Any objection?
No.
All right. Did you understand by pleading true to violations 4 and 1, the court could find it true, grant the motion, and sentence you up to 10 years in prison? Did you understand that? And up to a $1,500 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations 4 and 1?
Yes, ma'am.
Court will find violations 4 and 1 true. Is there a proposed agreement?
No, Your Honor, we were going to go.
Now here's the first real clash. The state wastes no time and recommends 6 years in the Texas Department of Corrections. For context, that's prison, not a short county stint. Why 6 years? Because probation isn't just about freedom, it's a contract. Megan broke that contract multiple times, and the prosecution wants consequences. But is locking someone up for years the right answer when addiction is at the core? That's the question simmering under every word in this hearing.
Open to the court. The state was going to recommend 6 years TDC.
All right. So the state is asking for 6 years. Defense?
Judge, I don't know if she was just sworn. Can I have my client testify briefly?
Yes. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right. You can lower your hand if you'll state your name for the record.
Megan Hayes Wilhite.
All right.
Megan.
Just one moment. There's Rattling. All right. Who are these people? Are they on the docket? The only people who are allowed in the courtroom are defendants. Sorry about that.
It's okay, miss.
Megan, you understand the state is recommending that you go to prison.
Yes, sir.
and you're asking the court to send you to safety.
Listen closely here. Megan is practically begging the court for one last chance, asking for Safe P, a state-run rehab program. She admits to years of drug use and says she's finally ready to change. But here's the problem: courts hear this speech often. Judges want actions, not promises. And Megan's record shows she's had chances before. Do you think the judge should take her at her word this time, or is it too little, too late?
Why?
I want the opportunity. I haven't been able to get any kind of help when it came to drug rehab, and I really do want the opportunity to be able to get clean. I think it's about time that I do something good with my life, and I believe that Safe P would be a reasonable option for me to be able to get clean and do the best I can for myself and my family.
What is your drug of choice?
Marijuana and methamphetamines.
Okay. When did you first start using marijuana?
When I was about 14, 15,
When
and
did you start using meth?
methamphetamines about 32 years old,
How old are you now?
38.
Have you ever received any type of outpatient or inpatient treatment?
No, sir.
In regards to the reporting, you didn't report for those months. Why?
I did not have a vehicle, and I had my belongings taken from me, from an individual that I was living with. My phone, everything, all of my email addresses and everything had been changed up. I had no way to contact anybody. And I was just go up to the probation office at that point. I already knew that I'd MTR'd, and I was just scared.
Okay. You understand that you
Her excuse: no car, no phone, no way to reach probation. But the judge immediately points out the flaw: she could have walked into the probation office at any time for help. This is a key lesson for anyone on probation: courts don't accept excuses. They expect initiative. Megan's failure to take that step will weigh heavily against her. What do you think? Is this a valid reason, or just another excuse?
could have gone up to probation at any time and they would have helped you and probably assisted you in getting your identification and that type of stuff, right?
Yes, sir.
Okay, but you didn't do that, right?
No, sir.
So you were placed on probation when, like last year in August?
Yes, sir.
Okay. You didn't receive any type of treatment?
No, sir.
Okay. And so you're asking for it because you don't want to use methamphetamine.
Most definitely not.
Passwords.
State, any questions?
Just a couple, Your Honor. Ms. Woolhite, you did have an opportunity to review the court summary, is that correct?
Yes, sir.
And did you see here that this isn't your first MTR?
Yes, sir.
And isn't it true that at the last MTR, you were told to go to outpatient treatment and that was a part of one of the conditions?
Yes, sir.
And you didn't go?
I don't think that the outpatient was available at that time. They had told me that I was taking classes, but that wasn't, I guess in the, how to explain this? They had me doing certain things at a certain time, and the outpatient wasn't at that time that I was going. I was going to classes downtown, but it wasn't treatment at that time.
Pass the witness, Judge.
No further questions.
I have a question. What classes are you saying you were going to downtown?
I was going to the theft classes.
All right. So what are you saying happened with outpatient treatment?
I hadn't gone to the outpatient treatment yet.
All right. Why not?
I had been working and I didn't have time to do it at that time. I hadn't been able.
This is where Megan gets caught in contradictions. First, she says outpatient treatment wasn't available. Then, under questioning, she admits it was available, she just didn't make time for it. That inconsistency destroys credibility in a courtroom. And credibility is everything. When a defendant changes their story mid-testimony, it signals to the judge, I'm not taking responsibility. And responsibility, or lack of it, will decide her fate today.
To make time yet.
All right. So this is what I'm trying to get to. One, was outpatient treatment ordered for you? Yes or no?
Yes, ma'am.
All right. Did you do outpatient treatment? Yes or no?
No, ma'am.
What is your reason for not doing outpatient treatment?
I was, like I said, I was working at the time. I didn't have the time at that period of time. I was going to be making time for it, but I did not have the time at that period of time.
All right. Because, and the reason why I asked that question, because, and if I'm wrong, everybody can let me know I'm wrong. I'm going to take that as a sign of disrespect. But it seems as though you were saying that outpatient treatment wasn't available when the state was questioning you. Did I hear that incorrectly?
No, ma'am, no, not that it wasn't available. It's whenever I was with Miss Martha Reyna, we were setting everything up. She had me doing the classes at that time, and I hadn't been able to do the outpatient treatment yet. Not that it wasn't available, because it was part of my agreement, but it just, she had me doing the classes. I was checking in and everything like that with her, doing my UAs and everything. I just hadn't done the classes yet for the outpatient treatment.
Okay. All right. Any other questions?
No, Judge.
No, Judge.
All right. Probation.
Yes, Your Honor.
What is probation requesting?
Your Honor,
Notice the probation officer's recommendation here. If she isn't revoked, then Safe P might be an option. But even they admit she hasn't completed theft classes, and this is a second violation. That word, second, is powerful. Judges may give you one chance. But by the second, patience runs thin. How many chances should someone get before the system says enough?
the recommendation on the court summary is if she is not revoked, then to send her to Safe P. I would like to point out this is her second MTR. And as she stated, it looks like she may have maybe entered the theft classes, but they were never completed.
Okay.
So at least we don't have record that they were complete.
All right. Anything else from either side?
Just brief argument, Judge.
All right. Then I'll hear argument state. You are requesting 6 years.
The prosecutor makes their strongest point here. Megan's had chances and squandered them. Even now, her answers about treatment are vague and evasive. To the state, this isn't someone ready to reform, it's someone playing for more time. Prosecutors often frame repeat violators this way, not as victims of addiction, but as manipulative offenders who only act sincere when facing consequences. Do you agree with the state's take, or do you see someone who still deserves one last shot?
Yes, Judge.
Is there anything you wish to add?
Judge, it's just, she's been given plenty of opportunities to attend treatment. Even when answering the questions on treatment today, she didn't really give an answer other than she didn't have the time to do it. She's been given chance after chance. That's why the state's recommending time in TDC.
All right.
The defense counters with a passionate argument. Probation's purpose is rehabilitation, not punishment. If Safe P works, Megan could finally get clean. If it doesn't, prison will always be waiting. It's a gamble, but one framed as a win-win for justice. This is a classic courtroom clash, punishment versus treatment. Which side do you lean toward here, the hard line of accountability, or the hope of recovery?
Judge, the purpose of probation is to rehabilitate individuals. I understand this is Ms. Wilhide's second MTR, but if she's given an opportunity in safety and she's able to no longer use methamphetamines in the future, then that's the win, that's the purpose. And if Safe P is successful, then she'll be able to complete the rest of her probation. If it's not successful, she'll be back here and you send her to 10 years TDC. So we're just asking for that opportunity to try to get her to treatment so she doesn't continue to use methamphetamines.
All right. Anything else from you, Ms. Wilhite?
No, miss.
All right. Ms. Wilhite.
And here it comes. The judge lays down the truth. Megan has started things, but finished nothing. Outpatient treatment. Skipped. Probation requirements. Ignored. Judges don't want excuses, they want results. And Megan didn't deliver. Notice how the judge also emphasizes that probationers can always come to the court for help. Megan never did. That's damning. This is the turning point. The moment her chances truly run out.
The problem is, it appears that you have started things, but you have finished nothing. And the problem is, you were given a chance at outpatient treatment and you didn't take advantage of it. I could understand if you did outpatient treatment and it wasn't working. And everyone who comes into this court who's on probation, I always say, if there's an issue, if there's something you have a problem with, if you feel probation isn't addressing it, you can always come to the court and say, Judge, this is not what they're addressing. Judge, I have a drug problem. Can you help me with that? Judge, I have mental health issues. Can you help me with that? we have an open door policy here. You can always come in and ask for that. But you haven't taken advantage of that. I'm going to grant the motion and revoke you. The state is asking for 6. Defense, what are you requesting?
Judge, we're asking for 4.
The hammer drops, 5 years in prison. The state wanted 6, the defense wanted 4, and the judge split the middle. But here's the nuance, this isn't just punishment. The judge also recommends Megan for therapeutic community treatment inside prison. It's a compromise, accountability for her crimes, but also a pathway for recovery. Do you think this balance was fair, or should the judge have gone fully one way or the other?
All right, I'll sentence you to 5 years in the prison. Give you credit for any time served. Is there still restitution owed? Because there were several people
Yes,
that
ma'am.
restitution was to be paid to.
Yes, ma'am.
So did they ever put in any amounts of restitution that were due?
Honor. No, ma'am.
All right, so they didn't put in any amounts, so I don't have any amounts, and if they want to do something with that later, they will have to take it up as a civil matter or somewhere else, but this court is not going to put it in the orders because I don't have anything. There's still to be no contact with the complainants that are previously listed. And let me write those down. If you would like,
This detail matters. The judge clarifies that recommending treatment won't extend Megan's time behind bars. She can still earn parole, but rehab will be available if she requests it. It's a lifeline, maybe her last one. But it's up to her to take it. This is a lesson for anyone facing addiction in the justice system. Opportunities exist, but you have to grab them yourself. No one will force you to change.
what I can do is I can recommend for you the therapeutic community. I am not in charge of whether or not they give you or place you in the program. You'll have to still request it, even though I put it on the form recommending it. It will not increase the length of time that you are in custody. So for example, if you're coming up for parole in 2 years or whatever, and you have not completed the therapeutic community portion of it, they're not going to say, well, we're going to give her parole, but since she hasn't completed the therapeutic community, we're going to keep her. That's not the way it works. It's just there for you while you're there. Would you like that?
Yes, ma'am.
All right. So I'll order therapeutic community. You're still going to have to ask for it. Okay.
Yes, ma'am.
I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right. Because this is not a plea bargain agreement, you do have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you were on probation. And state has tendered dismissals and the misdemeanor cases that are pending. All right. Is there anything else?
No, ma'am.
That's it.
All right. Good luck to you. Okay.
And there you have it. Megan Hayes Wilhite's probation revoked, 5 years in state prison, with a final shot at treatment behind bars. This case is a striking example of how probation works in Texas. Second chances are given, but they don't last forever. Megan's story highlights the thin line between rehabilitation and punishment, and the consequences when promises aren't kept. What do you think? Was the sentence fair, or should the court have taken a different path? Drop your thoughts in the comments below. And if you found this breakdown as gripping as we did, hit that like button, share this video with a friend, and don't forget to subscribe for more jaw-dropping courtroom commentary. Until next time, stay tuned, because in this courtroom, the drama never ends.